Part 2 of the Louisiana SSD Board of Directors meeting. February 28, 2023. A link to Part 1 is in the video's description.
Thank you, Dr. Martin. It was very awesome to hear. Okay, we're just going to move on. We're going to go to our next agenda item. Pat, our next agenda item.
All right. The report on and consideration of policies, with the first policy being the remote work policy.
Okay, so this morning when we were just kind of going through the meeting, there are a couple of ways we can do this. We can go through them one at a time, or we can do, if you receive these policies in your email, we can do something called in Globo, where we just approve all the policies at one time. So for me, I would like to do in Globo. We've all had the policies emailed to us. They're all within state's law.
I have several comments to make on some of these.
Okay. So we'll do them one at a time. All right, so do we want to just start with remote work, or do I need to make a motion?
Well, start with
Okay.
So I guess I would move adoption of number 8, remote work policy, and then if there's a second, then we can discuss it.
Okay, Ronnie. Okay, board discussion on remote work.
So I have just a few questions for clarity.
This is Sherry. Go ahead, baby. Well, actually, let's see, on teleworking. Oh, is that what we're doing now, the teleworking
Yeah.
policy? Okay, I just wanted to make sure. And I have a question for you. Page 2, it says appointing authority. Can you tell me who the appointing authority is? And Kitty's asking which page? Sherry's saying on page 2. The appointing authority, I'm not sure exactly who that person is.
Superintendent.
Superintendent, okay.
Okay, baby.
Yeah, so, it's a little bit unclear because it says that, the appointing authority shall determine which positions are suitable for telework. But then, under the request for telework, it says, or his designee. So is the final approval of telework rests with the appointing authority or his designee? So is it the appointing authority determines which positions are suitable, and then the request could be delegated? Is that the correct interpretation?
Come on up, Pat.
Good morning, this is Tommy Neary speaking. Let me cover one thing before we get to that question. You'll note that in the agenda, this is referred to as the remote work policy. The policy itself is entitled the telework policy. That is a reflection of state language. When we initially discussed this matter at the November board meeting, we discussed the remote work policy. But upon research of other agencies, particularly civil service, whose policy served as the model for this policy, state law and civil service rules use the term telework. So the reason I've titled it the telework policy, or proposing it as the telework policy, is just to keep us in alignment with civil service and other state agencies. I just wanted to clarify that difference in language between the agenda and the policy here. As to the appointing authority is always delegable, meaning that an appointing authority for any state agency may delegate that appointing authority. So here, delegation is going to be throughout this policy. So the appointing authority, I suspect, the spending some time with Dr. Martin, that he and Ms. Granier will work on that initial part, identifying what positions here are eligible for telework. Down there on the final approvals of telework, I think that's something that's more likely to be delegated by the superintendent to specific supervisors who may be more familiar with the workflows of the employee, the performance of the employee, and all those considerations we have, both the suitability of the position and the suitability of the employee to enter into a telework agreement. So just by the way civil service uses appointing authority, that's always something a chief administrator of an agency can delegate. Historically, that's resided with the superintendent here, and I would expect that to remain. But the intent of having a delegation specifically laid out down in the specific request for telework is so that the superintendent doesn't have to process every one of those, and that supervisors, if the superintendent would prefer, could be delegated that responsibility to make specific decisions about employees in their department or division.
Okay, and I appreciate that. On page 3, towards the bottom, the second to last paragraph, it says that shall be available to report, shall be available to report to their primary work site as directed by the agency. What is the agency? Like, who can require them to come in immediately?
In this case, it would be the approver of the agreement.
Okay. And then on page 4, it says that, SSD may conduct unannounced inspections of the teleworkers' alternate work site. So if that's someone's home, how is that done in practice?
In practice, not very frequently. It is more likely that there would be a revenue, and again, knowing both Ms. Granier and having talked to Dr. Martin, I would think those decisions are going to be made based on performance and not so much facilities. That language is to keep us consistent with civil service policy. I wouldn't expect that to be exercised very often. It is something that an employee that requests a telework agreement is going to have consented to, that they have sufficient facilities at home to engage in telework, and that if necessary, we can inspect those to make sure that they're appropriate work conditions. But again, if an employee is completing their work and meeting performance objectives, I think it's highly unlikely that there'd be any alteration of that agreement other than just withdrawal of it, as opposed to intruding upon their personal space if they can't get the work done. But again, we wanted to maintain consistency with civil service policy. This is a policy that, once approved, will need to be submitted to civil service, and we tried to mirror their policy as closely as possible.
That's all my questions.
Any other more questions on that policy? Okay, so the motion on the floor is to approve the remote work, telework policy. Do we need a roll call vote? Okay, Vicki? Sandy? Ronnie? Edward? Sherry?
Yes.
Maria?
Yes.
Kenny?
Yes.
Mary?
Yes.
So the motion passes. We will move to the second policy.
Policy is the Americans with Disabilities Act. It was approved at a previous meeting, correct?
So the agenda item here mentions notice or consideration of policies. I don't think we need an agenda unless someone would seek to amend this policy. At the November regular meeting of the board voted to authorize Ms. Granier to adopt this policy because the Division of Administration's Americans with Disabilities Act coordinator has requested submission of policies, and we wanted to go ahead and get our amendments done quickly and submit that to the Division of Administration. So this policy is here for informational purposes unless someone seeks an amendment to it. You'll notice that that policy has already been signed as of the day after the November board meeting. So we had drafted it in advance of the board meeting and requested permission for Ms. Grenier to adopt that. The board delegated that authority to her. So this policy has already been adopted and submitted to DOA. Of course, the board has the authority if they would like to elect to amend this policy. But currently, this is an adopted policy, and so if everybody's okay with the language of that policy, there's no need for a motion here because it's already been adopted.
I have a question. Since we have the language at the school for the deaf is ASL, does this policy include that those supervisors or others who go to interact with our teachers who are deaf, they should be the ones bringing in the interpreter for themselves, because they are the ones who need accommodations to be able to interact with the language of that school. So I want to make sure that that onus is not on our people who are deaf and use ASL, but that is, I guess it's a cultural issue, Dr. Martin, that it's the culture of the school that ASL is the language and interpreters need to be brought for those who don't communicate in ASL. So does this cover that?
It doesn't have direct language to that effect. It does incorporate Title II of the ADA, which is the effective communication title. And so we incorporate by reference those requirements. I will clarify that LSD is a bilingual setting, and the way we've worked with that and with Title II, the way it's interpreted and enforced in all public settings is that the requester of a meeting or the requester of a conversation is typically responsible for requesting an interpreter. Now, that certainly wouldn't apply in the student-adult situation. The expectation is that an adult who needs an interpreter, whether a child requests a meeting or not, that the employee would make that request and ensure that an interpreter was present. But in a peer-to-peer interaction between employees here, the expectation under the ADA and here at SSD is that the individual requesting the meeting will also make the request for interpreter services, regardless of whether it's the hearing individual or the deaf or hard of hearing individual that makes the request. When they request the meeting, they would also copy Ms. Covington and make a request to Ms. Covington's office to have an interpreter.
I've heard concerns from employees that sometimes supervisors or others sometimes have not brought in the interpreter that's needed to have those conversations. So I just want to make sure that that's something that is looked at as we move forward.
Okay, thank you. We will go to the next consideration.
Video monitoring of school property.
Okay, a motion to receive that policy. Ronnie, a second. Vicki, thank you. Okay,
Seconded by Ms. Smith.
yes, Vicki Smith. Is there any board discussion about the the video monitoring of school property? Board? Ronnie?
Yeah, I don't have a question specifically about, I don't think it's specific to video monitoring, but I have a question about the surveillance at the gate, at the main gate. My understanding is there's been concerns in the past about the system being out of service and can't accurately record folks that are on site. So I'd just like some clarification on that with regard to current status. Is that something that's in a state of disrepair? Is it functioning properly? Is there video surveillance at the main gate? Can somebody speak to that?
Is there video surveillance at the main gate and is it functioning properly?
And are we able to electronically record individual attendance at site accurately.
Well, and if I could add to that, just in addition to that, if we're talking about video monitoring on other parts of the campus, are we talking about hiring individuals to actively monitor all of those cameras that are going, or just cameras that are to be continuously recording without any active monitoring? I'm not sure if that was clear.
Dr. Martin and Catherine said that if there was an issue, then you would pull the cameras for review to remedy the situation or to get the information.
So Ronnie's question is, number one is there some dysfunction with the gate cameras? Is there, I guess, some question about whether or not they're actively working? And my question is, I guess my question was answered, is that they're not active monitoring, it's only passive video that can be pulled up after the fact. But Ronnie's question still is, are there issues with the gate cameras not working all the time?
As far as the camera working,
Yeah, and specifically, my question was about electronically recording attendance accurately. There had been some question about that in the past. My understanding is that system was not functioning properly. So there were concerns about who was on the campus routinely. But I just want to make sure to understand that issue has been addressed and that we can accurately record attendance at the site.
So I think what I'm hearing you say is there's two separate things that are going on. As far as we know, there is active camera feed throughout all our cameras on site. That is actually being done with LaTeX. That's the company that provided the cameras. We have the ability, certain administrators have the ability to pull video camera feeds, especially when we have investigations, so that we can kind of pull and review different cameras on campus. I think the other question you're asking about is the gate access. Right now, we had to pull the gate access. We were trying to combine that with our surveillance camera at the same time. The company right now was not able to do that for us, and we have gone with another company, and they're waiting on a part for us to have that attendance and records going in and out of the gate. Right now, our security at the gate is monitoring who comes on and off the campus.
I guess I have one other question, and perhaps I didn't read the policy carefully enough myself. But if there are already cameras throughout the campus recording, what is the purpose of this policy that we're voting on now? Is it to continue that process or to expand that process?
This policy is actually an offshoot from an act from last session from Representative Franklin Boyle, and I think Senator, right, I'm sorry, he was a representative. That was for cameras within the classroom for special ed classes.
So what we're voting on here is to increase the number of cameras to be inside of the classroom in addition to what's outside of the buildings? Is that what we're voting on?
Dr. Bell, this is Todd Neri. There is no active plan to expand our video monitoring program. We've already got cameras throughout the campus, in common areas and buildings, on breezeways, some external cameras. So the purpose of this policy is twofold. In the 2021 legislative year, the legislature adopted a new statute concerning the placement of cameras in certain classrooms in which students with disabilities are served. That's the second part of this policy that begins at the bottom of page 2, entitled Cameras in Special Education Setting. So one of the issues was to get us current with state law. So that was one of the reasons for this policy. Upon drafting that policy, and researching our existing policies, it came to my attention that we did not have a comprehensive policy that dealt with how we handle the video recordings that we make now, where they're stored, how they're accessible, who they can be released to, under what circumstances. So the primary intent here is to get us aligned with state law, but upon realizing we did not have a comprehensive policy for the district, I went ahead and drafted this as a more comprehensive policy that covered not only the cameras in special ed classrooms, which was legislated in 2021 and amended in 2022, but also to address the use of cameras campus-wide so that we have a clear policy and a clear understanding of how those videos are maintained and used.
Okay, thank you, Ty. In that case, I move adoption of the motion.
I have a question. If you look at page 3, number 7 and 8, it says procedures for approval or disapproval or request for the operation of the cameras in the classroom. Where is that list of the procedures?
Upon adoption of this policy, that will be our responsibility as the district to establish those policies and procedures. And I will consider your question here.
Have you developed procedures already?
We have not.
I understand.
The policy here includes a delegation to us to do that, and I will consider your question here now a request for us to inform you of those when we do get them adopted. So we will share those with the board upon adoption and development of those procedures.
Yes, and then we can add it to this policy.
I have a question. So we are out of compliance with state law because state law, we're supposed to have those policies done within 60 days of receiving the funding, which the district should have received the funding well before the end of the year, no later than January 15th of this year. Correct?
That's an issue with the legislation. No funding, it's a reimbursement program.
No, LPE gave out the money to each district. This
Okay.
district should have received it.
All right, I'm not aware at this point of whether or not that money has been received, but we have received no request for the inclusion of a camera from a qualifying individual. We've
But
not
we don't
seen
have the
it.
procedure, so how can a parent request it if we haven't even set up the procedures?
Agreed, and so we're remedying that today. We were supposed to adopt cameras in classrooms back in 2021 following the 2021 school year, and it did not happen then. It came to our attention upon the 2022 amendments, and we're rectifying that today.
But I just want to clarify, the money was received, and every school district should have received that funding.
Well, I don't know that they're considered a school district, they're considered a state agency, so they may not have received the money for that. I did not receive the money for me because I'm a state agency, but the agency I represent, allowed us to do that if we wanted to. So we're not even a school district, correct?
So on request of the reimbursable funds, we only received $6,000 out of that $1.8 million that was within the fiscal year. So we have not installed any cameras within the classroom, so we have not received any requests.
Okay, so you're saying, Mr. Morris, this is important, that every school district was supposed to get an allotment of that fund based on their population. So what I'm hearing you say is that the special school district got a really small allotment, which is really probably not the best way to do it since they have such a large population of kids with disabilities. So that may need to be brought up to
It was based
whoever.
on calculation from LPO.
Right.
We didn't have a part in that, so our share out of that was
So, I know that we've provided the superintendent an opportunity to meet with Superintendent Brumley tomorrow, and this might be a great opportunity to carry that conversation to Superintendent Brumley in that way. Superintendent Martin can get clarification on where we should be on that.
And I'm I'm sure it's probably just did a per pupil allocation and not gave consideration that 100% of your students are students with disabilities, so that makes a difference. I also have one other question. At the bottom of page 2, it says the implementation of this policy and any request shall be contingent upon adequate funding being available. And I don't think that that's accurate. I think the law says that it has to be done if you have a request. Now, school districts push back because of the cost, and so the legislature came back and gave some funding to help alleviate that kind of unfunded mandate. But at the same time, even if you don't have the funding, the school district still has the obligation to follow that law. Is that correct?
I don't have my statute in front of me, but I believe that language is directly from Title 17, 1948.
Okay, can you double check that? Because I don't think it's contingent on adequate funding. It has to be done, but the legislature allocated some funding to do it.
Okay, give me just a second.
And one last thing in regards to the procedures, I would feel more comfortable if we had a chance to review what those procedures are. I know that this issue has been something that has been really important to parents, and to have procedures that are appropriate, meeting the intent of the law. Not to say that someone's not going to try and do anything outside of what the intent of the law is, but I just think that this is a really important issue to parents of kids with disabilities. And so I would like for the board to be able to see the procedures and have some mechanism to be able to give some feedback before they're put in place. And I know that might be a little bit tricky because we're already beyond the deadline to get it done. So I'm opening that up for discussion, if there's some way for us to give input, but at the same time, expedite getting this done.
Yeah. Is that something that we could get on the May agenda for review for board consideration?
Certainly.
But I think that the procedures need to be in place because parents need to have that procedure to start making those requests immediately. So I don't know how. I know that's kind of a double-edged sword. So maybe that you could do establish some procedures, and then maybe in May, if we need to make some changes, we can make changes then. So at least we get the procedures in place.
Well, I think Ty had already said that his intention was to get those procedures down to us, as quickly as possible. I think today we're voting on a motion for this policy to go through. If we agree that the policy should go through, I don't know that we have to wait until May to receive those procedures from the school district. We could receive that next week via email, and if we have issues or concerns, we can certainly raise them at that time, and if it needs to be brought back up to the entire board, that can be done in May. But right now, we're agreeing that it's the correct policy to do, and therefore, if there are procedural concerns, I think we can handle those via email, or if we can't handle them via email, then it would have to wait until the May board meeting. But if we're all in agreement that the procedures are consistent with the policy and provide what we want them to do, then there's no reason that they can't happen as quickly as legal counsel is able to put it together.
Maybe one other thought. It sounds a lot like the conversation that we just had about the superintendent's contract and the need to establish the performance rubrics. The board approved unanimously to approve the superintendent's contract, recognizing there's additional work to be done with regard to putting the rubrics in place. So here, following Dr. Bell's comments, maybe it's worth considering the board to approve the item as stated, and then I believe that the board president has the authority to approve an emergency procedure, which would then come back to the board in May for ratification. So if we could get, comment on that from council, then, potentially the board president could, approve by emergency procedure, the work that, council responds to with, Ms. Bolzo is concerned, and that would not, delay, any request that would be submitted.
I agree. I mean, I tend to agree with Dr. Bell, just on, in general purpose, that when it comes to procedures and operating procedures, I think the most administrable way to do that is to delegate to the administration here, with an understanding that we will report back to the board, and the board has ultimate authority to amend those things. So as I stated to Ms. Crosby, on development of those procedures, we would share them with you. And if, in advance of the May board meeting, we got some indication from the board member that they had concerns about it, we would go ahead and put it on the agenda, rather than create a process or require the board to address it again between now and then. If this policy is adopted as written, it's going to serve as a delegation to the administration here to develop those policies. Again, if you, upon receiving those policies, regret that delegation, you could go ahead and direct the amendment of those policies, procedures moving forward. So that's an election for the board to make about whether y'all would like to handle it through an emergency procedure setup, whether you'd like to wait till the next board meeting to formally adopt procedures, or whether you would just like to let us move forward with this delegation and then submit those procedures to you when we've got them developed. And if you guys have any reservations about those, we can put them on the May agenda, and if you're happy with them, then we're off and running with this new procedure.
So to reiterate, today, the motion on the floor is simply to adopt a policy for this process to go through, understanding, as you just said, that the procedures, they may need some reworking. So I would move adoption of the policy as written currently.
Could we do that with the expectation that, policy procedure development will be expedited?
Okay, I'll take a roll call vote on that.
Excuse me,
Yeah.
the motion was made by Dr. Bell, seconded by.
Dickey?
Okay, yeah.
Okay, we're gonna take a roll call vote for the item that is on the floor. Vicky?
Yes.
Bailey?
Yes.
Ronnie?
Yes.
Edward?
Yes.
Sherry?
Yes.
Maria?
Yes.
Kenny?
Yes.
And Mary?
Yes.
And me, yes, too. Me, yes, too. Okay, motion passes. Okay, we have one more consideration of a policy.
The employee grievance policy is the last policy we considered.
Okay, do I have a motion to receive? Ronnie, do I have a second? Edward, is there any discussion that the board would like to have regarding the employee grievance policy? Okay, I'll take a roll call vote.
This is Sherry.
I'm sorry.
I'm sorry.
That's okay.
About this policy. When you're looking at the steps, step 1, step 2, 3, 4, etc., I'm not understanding why the days are not consistent. Like it's 7 days and then 14 days, there's a variance. Why not have a consistent number of days for each of the steps? And that way it would be fair to the griever and to SSD. They'd have the same amount of time. There would be 7 days for each of those steps. One is 7 days, then 14 days, then 21 days, and that seems to be drawn out. That seems too long.
I can just speak to my rationale here for, of course, we'll defer to board preference if you'd like to amend those dates, but I can speak to the process by which I developed this. Again, I worked from a civil service policy here and attempted as best possible to mirror our previous grievance policy, but also to take some cues from that civil service policy. The hope is that our grievance process doesn't extend past step one, but this is a recognition of the fact that as a grievance moves up through the levels, it becomes more removed from the situation where the grievance is held and allows those higher level administrators some additional time to gather records. It becomes a more formal process as it moves up the chain. So the intent is to give higher ranking individuals who are addressing the grievance sufficient time to come up to speed on it. Again, the presumption is that with step one, you're talking to your direct supervisor about a grievance you've got. Generally, that direct supervisor is going to have an understanding of the context of the grievance, the individuals involved, and the policies and procedures that apply there. As it moves up to a next level reviewer, they might not be quite so well versed in the specific context of an employee's grievance, the policies and procedures applying, and it's just to make sure that they have sufficient time to review it and issue their finding. And then, of course, with the final step being step 4, there's a necessity that we grant sufficient time there for the board because of the board's meeting schedule and the difficulty with which calling a special meeting presents to allow ample time for the board to get to it. So it was just a recognition that as it moves up the food chain, it's become more of a formal complaint. It's the reality of these grievance processes is that once it gets past step 1, it hasn't been addressed at the lowest level, and it's not going to be a quick fix at that point. We're into a more formalized process, and we want to make sure we give appropriate time for the people considering it to be deliberative in making their decision. I don't expect that those timelines would be exhausted routinely, but in the event that additional research was needed or additional data needed to be collected or people needed to be interviewed, we want to allow sufficient time for those people, and we don't want to create a situation where the superintendent is stuck with a grievance where he needs to get a lot of background information or she needs to get a lot of background information and only has 7 days to do it. Same goes for the board. So it's unfortunate that if somebody can't resolve it with their supervisor, speed is kind of out of the window at that point, and we got to trade off between speed and thoroughness of the process. And so this is my take on something that balances the need to resolve these things quickly, but the need to resolve these things comprehensively also. And so that's the balance I tried to strike in identifying these time frames.
Okay, another question for you. I know there's a timeline for the griever to fill out the paperwork, but then for the other side, whoever is reviewing the grievances and filed, reviewing the paperwork, do they follow any timeline? If they fail to follow the timeline, then the grievance should be waived, or, I mean, how does that work if the SSD office is not following the timelines and they miss those timelines?
That's going to be a matter of job performance for the individuals whose duty it is. I mean, we don't, these aren't adversarial proceedings like a court case where there would be some kind of default judgment or forfeiture for the SSD and a failure. We do have a process where the HR director can extend those deadlines for responses to a grievance, and that the expectation is that every employee here that has duties under the grievance process would do their best to get it done as soon as possible, within these timelines certainly, and in the event that a grievance was complicated or required an in-depth review of information, that employee that's responsible for responding to the grievance at that step would work with HR to extend it as short as possible while still getting it back to the grievant in a reasonable time frame.
Okay, so this does not give the person who is filing the grievance doesn't give them time to testify. That's not included. To give their side of the story beyond the paperwork, they should be able to do that.
The steps become a little more restrictive as you move up the steps, that is correct. But the initial step, step one, it involves an opportunity for the grievant to present his or her concerns to their direct supervisor. That may be in writing or in a face-to-face meeting. And typically at step one, that's handled in a face-to-face meeting. Step two additionally has an opportunity for the grievant to present his or her concerns. So there is an opportunity for interviews in step two. Step three allows the superintendent some discretion to determine what additional information, if any, is needed to render a decision. So in step three, we don't necessarily require that additional information be taken in from the superintendent. The superintendent will have the benefit of the information received by the step one reviewer, by the step two reviewer, and the decisions at step one and step two. If the superintendent were to decide they also wanted to interview the grievant again or collect more information, that would be in the superintendent's discretion, but that would allow for that. At the board level, I did restrict it, and this is, again, consistent with civil service policy, to a review of what happened before. One of the concerns here is that individuals using the grievance process who don't want to go through the steps might hold back some information in the hopes of just taking it to the level of the board. And we want to ensure that once it's been heard by the superintendent, all relevant information has been gathered, and therefore when it moves on to the board, that's going to be in essence a record review at the board level, rather than opening up full hearings at the board for grievances. So that is going to be more of an appellate process. So the first three allows for additional fact-finding, additional interviews, additional data collection, but once it gets to the board level, you are correct. We don't have a process for those individuals to come to directly address the board. It's just going to be a presentation of the prior steps and the information received in the prior steps, and the board will make its determination reliant on what's previously been collected through the grievance process.
I have a question. On page 3, number 3, it says the grievant would not be allowed to participate through representation or advocacy or having an advocate. Why not? Because the SSD would have their legal person. Why not the grievant have a legal advocacy as well? They should have that right rather than be representing themselves alone.
As it pertains to grievances, general counsel here would not work in an advocacy role. We would certainly advise on the process and that the policy was followed, but the agency would not have any representation. What we're trying to maintain here is a collaborative grievance process, not an adversarial grievance process. That's why we have an attempt to resolve it with an immediate supervisor and then working it up through the chain of command. If an employee thinks they have some adversarial claim against the school system, I would think that would proceed either through the civil service processes for certain areas which are grievable through civil service, or through existing legal procedures. But the intent here was not to replicate a court process where things get adversarial. This is an attempt to cooperatively address concerns people have about their work environment and the coherence to policies here at SSD. And that's the intention in not having representatives there, is that the attempt here is to find a cooperative, mutually agreeable solution to these issues and to start a collaborative process, not an adversarial argument, winner-loser process.
Okay.
So I have a comment. I agree that, I don't agree with the statement at the top of page 3, where it said that the grievant, let's see, there shall be no hearing involving testimony, the receipt of evidence, or additional matters before the board, that everything is coming from the superintendent. That is not the way I know any school system that works. In every school system, teachers have the opportunity when it gets to that point to be able to go provide their case before a school board. So while I know this is a state entity, if we want to have
comparable, education kind of expectations. This is the world in which educators work, and also we should give people the opportunity to share their story and be able to ask questions that maybe weren't given or weren't pulled by those people who have reviewed the complaint. So I adamantly disagree with not giving somebody a voice to be able to speak to us if it rises to that level.
Does council have any feedback on those comments?
I'll just reiterate what I stated to Ms. Crosby, which is at that point when it got to the board, there would have been at a minimum 2 opportunities, most likely 3 opportunities for that individual to have presented evidence and presented any arguments they wanted to in advancing their grievance. It's also an effort to reflect the role of the board, in that the board has but one single employee, and that is the superintendent. And so allowing the board to get between the superintendent and personnel issues here in such a independent way, I think post-Act 1 in Louisiana, most school districts even find that inappropriate now. If upon review of it, you find that the superintendent didn't handle it correctly, intervening in that employment situation between the superintendent and the SSD employment, in my book, would be inappropriate for the board, whereas it would be the board's role to treat that as a performance issue for the superintendent. So if the board feels like it's not getting adequate information on grievances, or it's being left out of the process, or the process isn't being adhered to, the board's main recourse in most any situation would be to have a conversation with the superintendent about it, and to ensure those procedures are being carried out more earnestly. But again, in my estimation, it undermines the superintendent if the board provides a direct route for individuals to come present information to the board about their employment situation, when the board is not party to that employment situation.
Would it be possible for the board, at their discretion, to call the grieving individual to testify if they did have concerns about the way the superintendent handled the situation?
We would need to amend that line in the policy that Ms. Polizzola has called out, that says there shall be no hearing involving testimony, the receipt of evidence, or additional evidence before the board, to reflect that the board reserves the right to request that under certain circumstances.
So I actually would agree with you, Ty. If we amend that statement at all, I would only amend it to say, in the exception of some extreme circumstance or something like that, because I was agreeing with Bambi here that in essence that we should strike that clause, that remember that employees should feel the right to come to the board, but I also have steadfastly maintained, as long as I've been on this board, that our job as a board, we only have one employee, and that is the superintendent. We have to judge the superintendent on what he or she does, and we're not the ones to make decisions about how the superintendent handles grievances within hiring and firing of the employees under his or her supervision. And if we determine that the superintendent is not doing their job correctly, then at that point, then we have the right to intervene and discipline or remove the superintendent, but it's not our job to micromanage. But I can agree that there may be some extreme circumstance where we as a board may need to or want to hear from the grievant in some circumstances, but I would leave the clause intact, other than to add to it that as Ronnie said, in some extreme circumstance or with exception or in some situations that it could be possible, I would try to soften it so that it's not entirely excluded, but I do agree that it is not the job of this board to hear the grievances of individual employees. That is the job of the superintendent, and our job is to supervise the superintendent.
And let me provide a little context and see if this addresses your concerns, Ms. Morris and Dr. Bell. A little further on in that paragraph, so let's just play out how this procedure could look. At the point where an individual brought the grievance to the board, that would be an agenda item on the board meeting agenda. Most likely, the board would recess into executive session to discuss that employee's grievance, because it's probably going to involve personnel concerns or character or fitness of an individual. So you would move into executive session. Upon return from executive session, there would be a motion made. I move that we uphold the superintendent's determination, or I move that we send it back to the superintendent with orders to blank. And that's laid out in these procedures, that you've got the ability to approve it or to amend it in some way or rescind it in some way. Upon that motion, we're going to have typical board meeting procedures, public comment, which includes the right for the grievant to comment. The intent here is not to silence the grievant. They're going to have their right as just a member of the public. Most likely, you're going to invite them back into that executive session, and you would have the right to that. What this is to foreclose is the introduction of additional information at the final stage. And to use the vernacular here, it's to avoid sandbagging, to avoid an individual who wants a hearing in front of the board from holding back evidence or testimony so that they get adverse decisions at the lower stages, so that then they can come in and have their Perry Mason moment in front of the board and say, look what I've got all of a sudden, and pull out a surprise last minute piece of evidence. It's to close that universe of evidence and allow the board to review only what the superintendent knew, rather than allowing the grievant a fourth bite at the apple. Again, the grievant, if there's a motion to uphold the superintendent's determination, that grievant's going to get a chance to come to the microphone and give their comment and say, I think it should be rescinded, or I think it should be amended for these reasons. What they're not going to be allowed to do is present new evidence that wasn't allowed for consideration earlier in the grievance process. And that sentence in here, it says the grievant may comment on the board's proposed disposition of the grievance. So we already have that in the policy, an opportunity for them to comment. It's not going to be an opportunity for them to present new evidence or arguments.
Thank you. Appreciate the clarification on the sandbagging concept and intent, and also that at the board's discretion, there could be an opportunity to hear testimony from the grievant in executive session. And personally, I think that's appropriate. It does address Ms. Polito's concern for the grievant to be able to speak to the board, and it would be appropriate that be in executive session. Thank you.
So I don't think it addresses my concern, because the policy still says there shall be no hearing involving testimony. So I'm just concerned that while what you said was that they could give public testimony, could this policy be viewed as there is a restriction from hearing any testimony, as in what you just described? So if we're going to do what he described, then I would like to see that clearly laid out, so that that's not construed as that there's no hearing of testimony, even in the public comment.
Okay, and let's talk about terminology for that. Would that, I'm working extemporaneously right here, but it seems to me like that would be something that would allow the board to request clarification from a grievant as to existing testimony or evidence.
I like to see the language reflect that this is an HR issue, and an HR issue should consider individual privacy, and those kind of conversations should be conducted in executive session.
Okay, so the addition of a sentence that says the board may, at its discretion, elicit clarification or additional comment from the grievant as it pertains to existing evidence or testimony. I'm not sure it would always be eligible for executive session.
Because that would be the discussion section of the motion there.
Right, if depending on the nature of the grievance, if it's not about the character or fitness of a particular individual, there's a chance that it would have to be a conversation held in public session, depending on the nature of the grievance. But if somebody just stated they weren't being allowed access to the gate, there would be no need to recess an executive session here, unless, again, we're talking about the professional character or fitness of an employee.
So I appreciate Dr. Bell's comment with regard to respecting the governance of the board and the relationship with the superintendent. Also appreciate your comments about potential grandstanding, sandbagging or whatever. I think that's appropriate to recognize that concern. And then the third thing, as Mr. Colzola has brought to the table is making sure the individual does have, appropriate opportunity to bring their case to the board. If the board so mirrored, there was a need. I'm not sure how we address all three of those, but I think those are the three sensitivities that have been brought to the table.
Because we don't have an agreement and it's just not open meeting and back and forth is not really conducive to working out specific policy language, then I would advise that the board go ahead and adopt the policy today and delegate to the acting superintendent the ability to sign off on this policy with amended language, taking into account the comments that I've heard today. We will go ahead and adopt the policy subsequent to this meeting. I will make amendments that reflect these comments without committing the specific language now. We'll submit that to the board, and if there's a request between now and May, we'll put it, now and May, we'll put it back on the May agenda. But in the interim, our current policy, the final step is to present it to Dr. Brumley. It's inadministrable. It's left over from before when we split off from LDOE, and I prefer not to walk out of here today without a workable policy. So again, my recommendation would be a motion to grant us the authority to amend it consistent with to adopt it, amend it consistent with the comments we heard today from the board. We will address that step 4 review language. I think I've got a good understanding of what y'all are looking for. Ms. Granier will sign off on it, and we'll get it to the board ASAP. And if we miss the mark on that, we can workshop language in advance of the May meeting and get it precise for then. But I'd prefer not to push this to May because of the issues we have with the current policy.
I'm just gonna reiterate what I already said, that again, 99% of the time, those employee issues are dealt with by the superintendent or by HR, and we don't have the context or the background to be able to make those decisions. So I move adoption of this motion as presented, again, with the same understanding that there may be circumstances in the future that we need to revise, but I think the policy is clear. Our job as a board is to supervise the superintendent. So I move adoption of the policy.
Okay, so we had a second already, correct?
It was Dr. Bell
Okay.
on the original.
Okay, so let's just make a motion to approve with all the comments and the information that Ty gave us, Bambi, Ronnie, Dr. Bell. We're gonna approve the policy today. Do I have a motion?
Can we get a clarification on what those changes are? Because I want to go back to the timeline. I think it should be 7 days for every step.
It can't be. If you're over a large institution and you have supervisors that work underneath you, it takes sometimes more time for, like a grievance would get to me as the head of my LDH facility. I could not do my due diligence, and it would question the integrity of the institution and the process. So the timeline to me is restrictive. There are times when there is a grievance that cannot get resolved at the very first step. It's very rare that we don't work collaboratively, but there are times that I need more time so that I understand everything that's coming to me.
So I think that this policy needs to reflect what's typically in our traditional public schools, because we have to be able to compete for those same employees. And if teachers feel like they don't have agreements with a policy that's going to be supportive of them, then we're gonna lose those teachers.
I think the policy is very supportive. I think it gives everybody ample time to truly understand what is at the core and how it could not be resolved from a supervisor to an employee. Once you go beyond that step, there are depths that a supervisor has to go to understand. I just think if you shorten, then the integrity of the whole process is thrown out. If you've never been over 200 people and you have other things that you're responsible for, there are sometimes it takes you that amount of time to get there. Now, if that's what y'all agree to, I'm good with that as well. I just think it questions the integrity of the entire process. If somebody told me I had to get something done in 7 days and I had to be out of town as the end-all be-all, the information I'm gonna get would not be, it wouldn't be what I wanted.
So, but it's not just that, it's also having an attorney or having representation. It's also about being able to present before the board. My comment was that this needs to be very similar to what is in the public school systems for their employees. That if we can go to that and we see that the public school system, this is the timeline, then I'm okay with that. If we see that public school teachers or employees can't have representation with them, or they can't speak before the board, then I'm okay with that. But I think we need to mirror what is in the traditional public schools, because we are competing for those same staff and employees, and also we should have the respect of giving them this process. Which, in all due respect, it was not done at the November 1st. This board showed that it wasn't doing its due diligence at the November meeting based on the comments I made at the beginning in regards to that, the minutes. And so I'm very concerned that our employees are not getting the due diligence and the process that they need whenever they have grievance. So I cannot support this at this time.
So do we go ahead and motion and take a vote?
Also, this is Sherry.
Yeah.
Mrs. Sherry, I have another question for you. What happens if the grievant has filed a grievance against the superintendent? Then who is going to review that? Would that be the SSC board?
Yes. Yes, it would be.
And does it say that in there? Does that have that allowed here in this policy?
Well, that,
The specific steps to handle this grievance on the board level against the superintendent?
Ty said he's gonna find it. It's in there.
So it's on page 204, up near the top. It's listed as a note there. It says, a step in the grievance process may be bypassed if the grievance concerns a decision or action by supervisory personnel within the grievance chain of command. I'm getting hungry. I'm going to start that over. A step in the grievance process may be bypassed if the grievance concerns a decision or action by supervisory personnel within the grievance chain of command, and the supervisory personnel cannot be expected to address the grievance in an unbiased manner. The decision to bypass shall be made by the Human Resources Director and shall not be subject to appeal. Additionally, grievances by the same employee or on the same issues may be consolidated for review. So the HR director, who's kind of the facilitator of the grievance process throughout this, has the discretion to allow a grievant to skip steps if it's believed that they are a supervisor or their supervisor, or the superintendent, if the superintendent is implicated, can't be trusted to give an unbiased decision.
I think that's pretty clear, but it might be worth adding to that clause that if the grievance is directly toward the superintendent, that the board is the point of contact, because that is a good point. If it is the superintendent, and the superintendent is in charge of over HR and everybody else, then You know, who allows that process to go, you know, we're the ones who oversee the superintendent. So if the grievance is directly against the superintendent, we're the place that they need to go to. So I do think we probably could clarify that a little bit.
I tend to agree that if the subject of the grievance is the superintendent, that it's most likely going to come straight to the board. What I worry about is not making that a deliberative process that resides with somebody. We can't allow the grievance to decide who they're grieving against, in essence. They'll provide a grievance that certain policies or procedures have been violated, that it affected them in a certain way. But somebody here has to evaluate and determine if the existing process is suitable for the resolution of that. And if an individual who's got a problem with the maintenance routine in their office, or the custodial routine in their office, could allege that it was the superintendent's failure to adequately supervise the operations that led to this failure of their office to be vacuumed regularly, and we're not going to be able to defer to the grievant as to whether or not that's reasonably something that should go directly to the board. And that's why typically, in my experience across state government, HR directors are fairly independent actors who have their certain regulations and rules to comply with. And certainly in my work with Ms. Patterson here, I trust her to be an impartial decision maker in that. The worst outcome of a denial to bypass steps is that individual has to go through a couple of steps before they get to your review. It's never going to deny them the right to a grievance or the right to eventually end up at the board. So while it could result in there being extra steps in their process, it's not going to be a foreclosure of a grievance. So I think that, speaking in legal terms, the potential harm of denial of that is just additional grievance steps. It's not a denial of the grievance process or a dismissal of their grievance. It's just, you haven't adequately discussed this with your supervisor. You think your supervisor can handle this fairly. Start at that level, and no, you can't bypass it. And that decision has to reside somewhere on campus other than the grievant identifying who they think they're grieving against. Because again, I think you're going to find every grievance here is a grievance against the superintendent if that gives you a free pass to the next board meeting to present your grievance to the board. And it's going to leave the board in a very unsafe position of having to do the initial fact finding all the way up. It certainly is unpreferred for the board to be the initial hearer of something because that's going to leave us to a full fact finding investigation at the board level, and we'd rather flesh that record out in the school district. It's my hope that, and this has been true since I've been here, the grievance process has not been very used very often, and I think it's a sign of a poor functioning workplace when the grievance is being overused. I would expect that what we've heard from Dr. Martin, that these processes won't need to be implemented. That we've got the individuals here will have access to the superintendent and his attention to their matters without triggering these formal grievance processes. And I hope they're fairly infrequent.
I appreciate the comments that you've made so far with efforts to standardize these processes with civil service requirements and so forth, so that we're consistent throughout the state. Ms. Pozzolo raised a concern about this process potentially being different than what traditional public school teachers are governed by. Has anybody looked at that? I mean, is there any difference or any significant difference between this process and the process that is used in traditional public schools?
Yes, no further off from those policies as they are from each other. There's really no standardization across school districts. They do, many of them allow for representation in front of the board, but I think that's a reflection of most being defunct and now collective bargaining agreements that simply haven't been remediated in school policies. But for the most part, especially post-Act 1 of 2012, boards have tried their best at the school district level to stay out of these types of personnel affairs. It's gotten some of our school districts in trouble where they have gotten between issues between the superintendent and supervisees of the superintendent, later attempted to discipline or terminate the superintendent, and the superintendent made allegations that the board had interfered in personnel decisions and was now seeking to discipline him for that. And so we've seen some of that around Louisiana, so I think that's made boards a little more hesitant to get there. Because of the variability in school district policies, and because we kind of straddle the line between a city, parish, or other local school district and a state agency, I went and looked at both school, and this goes for all the policies adopted here. I've looked at both school district policies, and from my prior work with school district, I'm very familiar with a number of school district policies. And I also looked at state agency policies. The state agency policies were pretty much consistent across the board based on the civil service grievance policy. Ours is nearly identical to the Louisiana Department of Health that Ms. Flynn was discussing earlier, and the Division of Administration, with the caveat that neither of those agencies, in fact, very few agencies, have boards. And I would ask you, Mr. Morris, have you ever heard a grievance from an LDOE employee at a BESI board meeting?
No.
It's pretty standard in the state agency, whether it's board governed or not, that again, the chief executive of that agency resolves those things. If that bubbles up to be a performance concern for that head of the agency, then that's something that will be brought to board concern. But I'm just trying to avoid potential for abuse here, and as we move into a new era of leadership here, to ask for some latitude for our new superintendent to handle things internally with board oversight, restricted to that oversight that's laid out in his contract, and him to be held responsible. If this is a concern that, and it is, based on the length of this conversation here, a concern that those grievances could be a source of problems down the road, that's certainly something we can include in the performance objectives of the superintendent's contract. That grievances will be resolved as soon as possible and within the timelines, and that we would report to you annually on the number of grievances we've received, the level at which they were resolved, how many days it took to resolve them, what the outcome was, and that would allow you all to adequately assess the superintendent and our administrative staff's ability to handle those things. And we just kind of, I think you'll be hearing me singing this song a lot over the next few board meetings as we prepare for a permanent superintendent. I'm going to be pushing for space for the superintendent to do his job with appropriate board oversight rather than getting down into the weeds of very seasoned administrators' attempts to put in place policies and procedures that worked here.
Can we have our board attorneys address this, please?
Come on, I'll bring it up.
Can everyone hear me? I understand the issues of concern. And looking at on page 3, where it says, basically it's saying the board will not have the right to ever have or hear any evidence. I think that's wrong. I think you could say, except upon special motion and approval by the board, comma, there shall be no hearing involving testimony, et cetera, et cetera. That way you're not drugging the weeds. You can invite yourself to go in the ditch if you need to, right? But you're not dragging it every time. And you need and should have the discretionary authority to, if necessary, you'll never, but if necessary, to review a decision. If it is a claim directly against the superintendent, as written, you couldn't have a hearing on it. I don't know how that would take place as written. And maybe it's a linguistics thing, but as I'm reading the plain language, you couldn't do that. And I agree with Ms. Pollack-Zollman that there needs to be some avenue to do what this board is here to do. We mentioned earlier, there's one employee, the superintendent. We should and need to have the right to look at that. So I would propose to this board that we modify the language at the beginning of that sentence to say, except upon special motion and approval by the board, comma, there shall be no hearing involving testimony, et cetera, et cetera. You need that right, and you should reserve that right to yourself for the appropriate circumstance. I don't know about the decision to bypass being in one person that's under the control, or certainly in the hierarchical command of the superintendent making that call on bypassing. It almost could be a situation where it seems self-evident, really, that if you're making a claim higher up the hierarchical chain, that it would be redundant or stupid to try to go below that chain. Should you start at the top where the issue is? I don't know how we massage that or work around that with specific language, but the point is acknowledged, and it may need to be tweaked going forward. My only other comment has to do with the lack of representation. I'm not comfortable telling you to take that route, i.e. prohibit all representation. I know at regular school boards, I've represented teachers and other people at school boards when necessary. And there could also be a problem with ADA accommodations. Somebody needs help hearing or understanding, so they can't have a person there with them. As written, it says no representation, and maybe we could make a note and mark that to be tweaked as well. That's all the comments I have.
I would agree with your two suggestions and move that those changes be made. One, that the board does maintain the right to, the way you stated it, that except for exceptional circumstances, the board does have the right to call, or review the witnesses as or the grievance as necessary. And also, I do agree with striking the clause that says that no representation can be held. I would support those two changes.
Need a second.
Okay, so we're gonna have a roll call vote to support the two changes that Andre gave to us, to include possible representation, and what was the other one?
Going with on top of page 3.
Yeah.
There was a except upon special motion and approval by.
Okay, so that's what we would be voting on. All right, I'm gonna do a roll call vote. Maria?
Yes.
Dr. Bell? Sherry?
Yes.
Wait till Kitty gets back. Miss Glenn, yes. Michelle has left. Ronnie?
Yes.
Muslim Hicks is not here. Bambi?
Yes.
Mary?
Yes.
Oh, I forgot. Sorry, y'all. Nigel, do you want to speak on this?
There's a 3-minute limit, is that correct?
Yes.
Can you see me okay? Hello, this is Nigel. I interpret for deafblind individuals. I'm a dark-skinned person with a black polo shirt tucked in. I have an afro, and there's a screen behind me for skin conscious purposes. So we're talking about grievance procedures, and I'd like to thank Ty for emphasizing that we are working to collaborate for a resolution, and I agree with that. And I would like for you to think about policy, the document, and the procedures that are going to be documented. So, and having the form that people start with, and then they send it in, and then there's a response to it. And the investigation that's included. Can we have that included to the grievance, what investigation took place? I think it's very important. As Dr. Martin mentioned, we need to have transparency. And so people need to know what information has been communicated throughout the process. So we could have that in the policy, we could have that documentation. And then also, I would like for you to remember, the grievance process is public record, and it can be requested via public record request. And so if we have that available, maybe we could be having something that's standardized. For the people who are working here, they would have the same information. If you would, please consider those points.
Thank you, Nigel. Okay, with Nigel's remarks, do we have any other board opinions? Okay,
Just to be clear what Nigel said, in this policy, the grievant does have a right to all of its records. Is this a policy or is that just normal
public record.
public record? But if that's,
I would say again what you're asking.
it's not public record, because that would be, I think that's confidential, some of that could be for the employees. So I'm just, what I think he was saying was, does the grievant have access to all the records in all these responses? I would think so, but where does that right come from, I guess is my question.
Does the grievant have access to all of the records that would have been paid going through the first step, the second step, the third step? Would the grievant have access to that?
Anything relied on.
This is Tom here. The grievant would have access to anything considered in reaching a decision in any step. It would be included with the written decision. At each step, there's to be issued a written decision, and if any documents are considered or any data is considered, that would be addendums to that written decision. So by the time they've moved through 3 stages, they would have 3 written decisions and the information considered at each of those decision levels. With the caveat that just because you file a grievance doesn't give you the right to confidential information about students or employees that wouldn't otherwise be accessible to you. I do agree that in a general sense, grievance documents are public records, but some components of those grievance documents may not be public records. So I would give the caveat that certain things are made confidential and accepted from the public records law. To the extent those can't be shared with the initial grievant, we would have to either provide redacted information if possible, or just a description of the document that we're not able to provide, but was considered.
Okay, so we will start again with our vote. I know Kenny had to walk out, so if it's okay, I'll just go over it again. We're going to.
I apologize for that.
Oh, you're okay. We are gonna take a vote to adopt the employee grievance with the modifications that have been given to us by Andre. So, Maria?
Yes.
Dr. Bell?
Yes.
Sherry?
Is that the same motion as before?
Yes.
We're just voting on it again?
Yes. Yes.
Okay, then yes.
Kenny?
Yes.
Michelle Jones is not present. Ronnie?
Yes.
Ms. Muslow Hicks is not present. Bandy?
Yes.
Mary Smith?
Yes.
Vicki Smith?
Yes.
And myself, Christy Flynn, yes. Okay, the motion passes, so we will move on from the policies. Next agenda item, please.
Acknowledgement of LCD letter and plan moving forward.
Okay, so at this time, the board wanted to recognize to LCD that we have received the letter, and we are gonna be working closely with Dr. Martin to resolve any issues that he is not able to move forward with the LCD board on. We're in support of working with LCD so that we have a better understanding of the deaf community. And we want to work closely with Dr. Martin so that we have a united front. And we want him to know us and us to know him so that when we move forward, we're united and we address all the issues that were in the letter. I think Dr. Martin has already made pretty great strides in the information that he's given y'all, an open door policy. It's gonna take him some time to get to understand certain items, but that he is willing to address all community stakeholders who have value to what the SSD does. So basically, this is just, I need a motion to receive that the board recognizes the LCD letter and that we're gonna be working closely with Dr. Martin to move forward on the issues that were addressed in that letter.
Move adoption of the motion.
Okay, thank you. Do I have any?
Yeah, I think there's a misunderstanding of the letter. The letter was made to us, not to the superintendent. It's not about the superintendent so much as understanding the concerns of the community. It's about the board understanding the concerns of the community. And they specifically asked to have a joint meeting. Ms. Faulkner requesting a joint meeting with the SSD board. And so I think that we should try and at least set up a time to be able to meet with that or have some type of decision.
Ronnie?
But, well,
in conversations I had with council on this, my understanding is that there's an audit, it's in process right now.
Yes.
And there are some legal considerations that we should take into account with regard to the audit in process that covers, I think, all of the items in the letter. So I'd like to get some words of wisdom from the council on this.
Yeah, and I have let the board know that I have been in contact with the legislative auditors who are reviewing SSD. And one of the things that they took into account was the letter from SSD, and they were gonna review the items listed in that letter and be able to get back with us, hopefully by May, but they said the latest before the start of the new school year. And if you know anything about legislative audits, they are very tedious and they can last a long time. My facility, before the transfer from DOE to LDH, it was about a 9-month process, but we really came out of that process much stronger as we could really delve into the issues that we had and where they were stemming from and how to fix them.
the only other thing that I was gonna say is that we've, our SSA consultant talked to us at the very beginning of the meeting about having like a 2-hour training in May, and I don't know if we want to extend that longer over lunch period or whatever, but I think it's been said here several times today, part of this is sensitivity training. I don't think there's anyone in this room who doesn't care about the concerns of the LSD or the
LCD.
or excuse me, the LCD, yes. And I think, you know, we want to get to know them, their concerns, and what we as a board can do to help them. But, you know, can't we do that in a social manner, maybe over a lunch, so, you know, does it have to be an official board meeting? Or can we just, you know, get together and work together? You know, I don't know that this has to be a confrontational or adversarial meeting, is I guess my point.
Ronnie?
Yeah, just just add to Dr. Bell's comments, in addition to any concerns we might have, because in audit is a process, I think the board would be better advised as well. If the board, had the audit results in hand, the board would be better prepared, better informed, to make an intelligent decision regarding the, any specific concerns here. So I think that's real important that the board have that audit background. I think it'd be a lot more quality in the process. And at the same time, as has been mentioned several times here today, Dr. Martin is very engaged with all stakeholders. I think got specific meetings scheduled to visit today to address some of these concerns. So I think he is being responsive, I think appropriately responsive. I want to acknowledge him for that effort, and appreciate the fact that the board is trusting Dr. Martin to take that leadership role. Those are my thoughts.
Is there any other board comment? Do the attorneys want to weigh in on, this was just a motion to receive a letter amending the item.
Larry Rodell, I know we have too many attorneys here probably. The letter from LCD raises some important issues for consideration. The legal team tends to agree with what Mr. Morris just stated. The issues are under consideration, perhaps studied by the audit. It would seem to be a bit premature to set a joint meeting at this time until this board is armed with the results and the opinions of the audit. So that's kind of where we stand as the attorneys. Thanks.
Okay, so a motion of the public comment. Okay. Jay?
Yeah, I'm not sure there's an opportunity for public comment. There's not a motion on the floor for a vote. Is that right?
Yes, I did. Well, I made a motion to receive the letter.
So motion, I'll second the motion, then there can be discussion.
Okay.
Christie, excuse me, Dr. McBell made the initial motion to receive, so can there be a second? Well, someone else will need a second.
Okay, I'll second.
Okay, thank you.
Jay?
Thank you. I'd like to comment, I'd like to thank you for recognizing the LCD letter is important. I'd also like to talk about the 4 letters that LAD has sent to the board. There are 4 letters that have been ignored. June, July, August, September, about the IDEA money not being used, recruitment of staff, retention of staff. So we have 114 vacancies. That is a concern because the deaf ecosystem is very important. It's a school for the deaf. It acts as an ecosystem for the deaf community, for the opportunities that are available here on the campus. There's only the one. What other opportunities are there for deaf professionals? So Dr. Martin, I'd like you to really look at the funding, the IDA funding, to make sure that it is used for staff recruitment, retention, raises. Morale is very low, and the staff are feeling like crap. They're not feeling respected. It's very important to look at that, and I'm hoping that the board will look at the LAD's letter once again and realize and consider and respond to LAD. LED is fighting for the LSD students. The LSD students have been here for over 100 years. We're feeling as an organization that we are not being respected. So we would like to work together for the best of the students. It's not about a battle between the adults. It's about the kids. It is about our future. I appreciate the time.
Thank you, Jay, and I think the board, we certainly see it the way that you do, that we want to work together. And I think, you know, as a new board, even though we're a year old, we're still getting our footing, and getting a new superintendent was very important to us because he is the person that we oversee. We want to make sure that we are in line with what his visions are. And we have read the letter and do respect what we've read. And through that process, the legislative auditors are going to be able to tell us what's in the letter and what we need to do to fix it. So I certainly appreciate your comments. Is there any other public comment? Okay. Next agenda item, please.
Is there a vote on that, a final decision on that motion?
Do we need to vote for that? Okay, so a vote to receive the letter from the Louisiana Commission for the Deaf. And I will go ahead and just do a roll call. Maria?
It's not clear to me what we're voting for. Can I get some clarification on the motion?
Motion to receive the letter that the LCD board sent to the SSD board. So we are making an acknowledgement that we did receive the letter.
Okay, I'm understanding now. It is clear.
So we would just vote yes, that you agree that we received the letter, or no, that you don't.
Yes.
Okay, thank you. Maria, Dr. Bell.
Yes.
Sherry.
Yes.
Kenny.
Yes.
Ms. Jones is not here. Ronnie.
Yes.
Ms. Muslow Hicks is not here. Bambi.
Yes.
Mary.
Yes.
Vicky.
Yes.
And Christy, yes. Okay. So we're gonna move on to the last item on our agenda. And that's gonna be the personnel report. Ms. Santa is here to give us the information.
Hello, I'm Santa Patterson. I'm the Human Resources Director. I'm going to be giving you an overview of the appointments, transfers, leaves, separations, etc., since the November 1st date forward. Give it a moment to project. Okay. My data that's coming is coming from the MyGov system, our personnel system that the state uses. And it's as of data entered as of February 20th. So it's from November 1st through February 20th. We have 10 appointments, that is hires and rehires. That's new individuals coming to join us as employees. We had a total of 5 internal organizational assignment, that's position moves. So let's go forward. 10 appointments and 5 internal organizational assignments since November 1st. Leaves. During the November period forward, we had 4 employees on extended sick leave. We had no sabbaticals, 4 employees on extended sick leave. And for FMLA, we had 17 employees approved and 1 denied that did not qualify for FMLA. Also during this period, we had 6 new employee workers' compensation incidents reported. We had 1 transfer out to another state agency. Now, our separation actions, we had, in LOGGOV, they combined separations along with retirements, because that's a type of separation. We had 12 total separations and 2 retirements. And then we have 1 retirement that's effective this week that's not shown in the report, but I included it because I knew I had been notified and it is effective. That concludes the total appointments and actions since November. Thank you.
Santa, I think Ronnie has a question.
Yes, sir?
Yeah, thank you. First of all, thank you for that report. I know we're all looking forward to the superintendent getting his feet on the ground and getting some appreciation for what the staffing situation looks like and advising us of the current situation and what his plans are going forward. But on page 6, on page 6, I noticed that there were 6 injuries.
The workers' comp injuries?
Yeah, so I'm concerned that in November, there were 3 injuries reported in November, and again, in February, 2 injuries that were reported.
Now, this is district-wide.
Yeah, I get it, but still, the environment I'm accustomed to, the policy is nobody gets hurt, right? So, that would be my expectation here too, right? Is the policy would be that nobody gets hurt, right? Safety is number 1 priority for children, adults, everybody, right? So, I'd just like somebody to speak to that a little bit. I realize it's a large district of multiple sites and so forth, but at the same time, sincerely posit that safety is the number 1 concern, and 6 seems like an awful lot to me. I'd just like someone to speak to that.
I do realize our injuries reported include everything, such as a slip and fall, trip. It's not all severe injuries. But yes, this runs the gamut through every category of employee. Regardless, it's not all instructors, it's every type of employee, every category. So any injury, we do report, we do an incident report. Not all involve lost time. So some were just a matter of they tripped, hurt their ankle, and it turns out to be not any lost time. Others are more serious where they're actually out. And I agree, safety is paramount. But that number is, I've only been in the director's role since February of 22, but it's pretty consistent. It's less in the summer because we have fewer employees on campus, but this includes all of our employees, including employees at Juvenile Justice and Pinecrest and statewide. So it does happen, and I do agree and I embrace any suggestions that we can have. We do use Sedgwick as our workers' comp claims, and we are dialoguing with them, and we do investigate. So
I'd just like to bring to the superintendent's attention that it's a concern that I have, and when we have these conversations about culture and what the culture looks like going forward. For me, this would be a high priority in nurturing that culture as we go forward.
I also have just a quick, and this is a question, not a comment. 17 FMLA requests from November to February. To me, that seems like a very, very high number. Is that, in your experience, is that normal? Or is there some reason why this is such a high number?
I don't think there's one reason, one concise reason why. Some of these are understandably things like surgeries and such, but no, it does. I've worked at many other state agencies in past years in my career, and this does seem a little higher than some that I've worked at in the past, but not astoundingly higher, but I have seen higher.
Thank you. It struck me as a high number, but I don't have the background to know, so thank you for the clarification.
Does SSD have a safety director? Somebody that is responsible for like evacuations, all of the, if there is an incident, investigation.
Jeff Jacobs is over operations, and he is over our risk management and public safety.
Do you know if he has like monthly safety meetings with his
Yes, we
supervisors?
do.
Okay.
We do have safety trainings, and he does have meetings. He is making strong efforts at communicating to try to get 100% compliance in all the risk management requirements. It's some of these things that I think are happening are not necessarily directly under Jeff's control, because some involve things that are just unexpected, totally unexpected. Thank you.
Okay, are there any other board comments about what Santa presented? Okay, the next item on the agenda is adjournment, and I just need a motion to adjourn. And a second? Ronnie and Danny. Thank you so much. We will see y'all next time.